là, puis après on met les autres. Ça n'a pas besoin d'un million d'années. Non, on ne touche à rien, on parle dedans. Des fois, ça arrive qu'il y a une seconde le temps qu'on monte le volume simplement. Pas besoin de la personne taper sur le plus 0 le volume. C'est bon comme ça?
We should have put some water in that. Fluorescent here too. Okay.
Excellencies, colleagues, dear students, ladies and gentlemen. In the framework of the Women in World Affairs lecture series, co-organized by the Graduate Institute and the Permanent Mission of the United States of America to the United Nations, it's a great pleasure and an honor to welcome Judge Joan Donoghue this evening. Judge Donoghue was elected to the International Court of Justice in 2010, following a career at the US State Department, where she served as the principal deputy legal advisor, the senior career attorney, from 2007 to 2010, advising Secretary Clinton and President Obama on all aspects of international law. Her work at the State Department spanned diverse topics in public international law, such as the negotiation and interpretation of treaties, the law of the sea, Antarctica, the environment, investment, human rights law, and international humanitarian law. Judge Donoghue has had extensive experience with various forms of international dispute settlement, including claims agreements, arbitration, and adjudication. She has presided over arbitral tribunals in the field of foreign investment and also, before becoming a judge, appeared before the ICJ in the US teams in the Nicaragua versus USA case and in the advisory proceedings on the unilateral declaration of independence in respect of Kosovo. She has also taught at several US law schools, including George Washington University School of Law and Georgetown University Law Center. Judge Donoghue is the author of a number of publications in the field of public and private international law and has lectured frequently on aspects of international adjudication. I personally had the pleasure to share with her a panel on the ICJ and the international legal system in 2013 at the occasion of the centenary of the Peace Palace, and another one on ethics in international adjudication during the International Law Week in New York in 2015. This time, it is my pleasure to welcome her in Geneva. Today's topic is the role of international courts in global governance. At all times, the creation of international courts and tribunals has been perceived as a decisive progress towards the advancement of peace and justice in international relations. The old dream of a perpetual peace and its manifestation in different projects has as a component the idea of an international adjudicative body or bodies having compulsory jurisdiction to deal with all international disputes. Why this vision? Because judicial settlement by an impartial body seems to be the best option to the alternative of the use of force. Given the composition of the international society, this dream looks as an impossible task. What has not been impossible is the creation of one court having general jurisdiction, like the ICJ, and a multiplicity of courts, tribunals, and quasi-legislative adjudicative bodies with jurisdiction in specific fields, such as human rights, the law of the sea, international criminal law, world trade, foreign investments, etc. However, for all of them, state consent is indispensable. The expectations are that these bodies not only settle the disputes that are submitted to them, but also that they contribute to the ascertainment of the relevant law in general. Sometimes the perception of adjudication as the panacea of dispute settlement leads to disappointment. Judge Donoghue will address the aspirations that we should have for courts, such as the International Court of Justice, delineating their limits at the same time. So without further ado, Judge Donoghue, you have the floor.
Well, first let me thank you, Professor Cohen, for your kind, generous introduction. Thank you to the Graduate Institute for having me here today, and to the U.S. Mission for cooperating with them. And thanks to all of you for being here on this evening, which seems like a very beautiful evening to me. And Professor Cohen mentioned that we'd been on a couple panels together, but what he didn't mention is that I see him, and he sees me quite often, but at quite a distance, because he appears quite regularly as counsel before the International Court of Justice. We're not in a position to chat in those cases. Let's just say I have much more experience listening to him than he has listening to me. So this will be a turnaround for us. So as he said, I'm going to talk today about international courts and offer some thoughts about the expectations that we should have about them. And as you might expect, I will focus primarily on the International Court of Justice, and I'll make a few brief comments as well about investor-state dispute settlements. I just want to start with two introductory comments about the scope of my remarks today. As Professor Cohen mentioned, there are many different kinds of international courts. There are criminal courts, for example. Most of my remarks today are of greatest interest when one thinks about a court where at least one of the parties is a state. So that would include the International Court of Justice, the International Tribunal for the Law of the Sea, and it would include state-to-state arbitration, for example, arbitral proceedings that are held under the auspices of the Permanent Court of Arbitration in The Hague, and of course here in Geneva, the dispute settlement body of the World Trade Organization. And I also have in mind, when I speak of proceedings to which at least one party is a state, I also have in mind investor-state dispute settlement. And then my second limitation in terms of the scope is the ICJ has a role that goes beyond the settlement of contentious cases between two states, because we also render advisory opinions at the request of another UN organ. About 80% of our docket historically, although that number's a couple years old, so I'm not sure how it would have changed, but in general, most of our docket is on the contentious case side, and that will be my focus today. So I've been on the International Court of Justice for 8 years, and soon after taking the job, I decided, in collaboration with the American Society of International Law, that I would try to find opportunities to speak about international law in the United States in particular, and especially to speak to general audiences and skeptical audiences in what I sometimes refer to as my red state tour. And I also have spoken elsewhere in quite a number of places in Europe. So I've spoken to general audiences, sophisticated audiences, and I assume that many of you are quite knowledgeable about international law generally and about dispute settlement in particular. But if I look at all of these exchanges that I've had, I would distill what I see as two recurring lines of questions. The first line of questions proceeds from the premise that international courts should be made stronger, and those questioners want to explore ways to strengthen the courts, essentially often kind of thinking about national courts as the model and trying to think about ways to make international courts function in a legal system more like national courts. The other line of questions that goes in the opposite direction, and that I especially hear in the United States, although these are not by any means the exclusive questions or even the dominant questions, go in the opposite direction, and those questions go something like, why would any state ever relinquish its sovereignty to an international court, and why would a state ever comply with these decisions from an international court? So I've stated those questions in simple terms that might be used by somebody who's not an expert. But when we look at the very large literature that we have on international courts, the large scholarly literature, we see all kinds of detailed analysis of questions like the effectiveness of international courts, compliance with the decisions of international courts. We've got extensive discussion of the question of proliferation of international courts, and especially recently, analysis of the advantages and disadvantages of international courts as compared to other forms of international dispute settlement, such as mediation and conciliation. So when we in the field write and talk about these things, we employ a variety of theoretical frameworks and, of course, our extensive knowledge of the details, procedure, and substance in these courts. But at the heart of our scholarly inquiries, we're often back to the same basic questions that I might get from a high school teacher in Idaho or a state judge in California. How does this work? Why would states relinquish their sovereignty to an international court? And so what has struck me throughout my engagements is that the most basic questions are actually also the hardest questions. And so today I am, in a way, looking back to basics a bit, but with a view towards reminding us all that the basic questions remain difficult. And the basic question, as I see it, is what are the appropriate roles for international courts and tribunals, and how do we know whether a particular court or tribunal is successful or failing at whatever its appropriate role is? So, so that raises the question, well, how would we know? Against what metric would we evaluate a court? There are various ways we can do it. There's more than one way that you could answer that question. But one metric is to consider the performance of a court in relationship to the goals that were established by those who created it. So in the words of Professor Yuval Shani, who's written a very useful book on the effectiveness of international courts, we ask ourselves, what were the goals of the mandate providers? So I want to spend a minute just recalling where did this idea of a world court come from? And that has to take us back to the Hague conferences in 1899 and 1907. And there, the idea of a world court was pushed with great fervor, and there was considerable study of the proposal there. The proponents were very ambitious. Many of them hoped that if we could create a world court, we would design a forum where states would go to court instead of using force to solve their problems. Well, the two Hague conferences did not produce a world court, but eventually interest in World Court continued, and eventually we had the Permanent Court of International Justice, the First World Court. And then, as part of the UN Charter, we had the United Nations principal judicial organ, the International Court of Justice, where I sit. So it's interesting to compare the proposals of these World Court aspirants at the Hague Conference to what we now have in the statute of the International Court of Justice. So just to review a few of those, we can see that certain of those original aspirations for the design of a World Court were fulfilled in the statute of the International Court of Justice. The ICJ is a standing court, not an ad hoc mechanism like those that existed before the Permanent Court. The ICJ has scope to settle the full range of disputes. Some proponents of a World Court at the Hague Conferences wanted to limit the World Court, exclude certain disputes that were considered too sensitive, and that did not happen. So there are no per se exclusions such as those. The decisions of the ICJ are binding on the parties to a case. And also, those present at the Hague Conference and involved in the drafting of the statute of the court recognized that the decisions of the World Court would have the potential to influence the behavior of states that were not parties to the case before the court. And that could only happen if the decisions of the court were public. So that is the case for ICJ judgments and orders. Our hearings are public, our judgments are public, and our orders are public. Well, under our statute, the court's decisions bind only the parties to a case. And so formally, our decisions are not law for states that are not parties to the case. And in that respect, our court does not operate like a common law court does. However, it's inevitable that in the course of the court rendering its decisions and performing its explicit functions, both in delivering advisory opinions and in settling disputes, it's inevitable that the court's public decisions would give rise to a jurisprudence. And we have to think of that, I think, as an implicit goal of those mandate providers that set up the court. So in these four respects, we can say the design of today's World Court meets the aspirations of the Hague Conference: a standing court, no cases excluded per se, decisions are binding, public decisions that allow for the development of jurisprudence. But, and Professor Cohen alluded to this, there is an important way in which the ICJ falls short of the aspirations and ambitions that drove the Hague Conferences. And that is the fact that under the UN Charter and the ICJ statute, states are not required to accept the court's jurisdiction, nor are they required to submit disputes to the court. As a result, the court's ability to fulfill the mandate that was assigned to it depends on the decisions by states both to accept the court's jurisdiction and to submit cases to the court. Well, the statute does not leave states with a binary in or out choice. They may accept the court's jurisdiction unconditionally, or they may do so with stated reservations. They may accept jurisdiction only with respect to specific treaties. They may accept the jurisdiction of the court only to decide a particular known dispute when two states agree and bring it to us. And they may modify their consent to jurisdiction over time. And so what that means is that states' consent to our jurisdiction or their lack thereof can never be taken for granted. States can, and they do, change their attitudes towards international adjudication over time. So that's how they accept the court's jurisdiction. So what does the record tell us about state confidence in the International Court of Justice? Well, if you look at the docket of the court right now in comparison to the way that it has looked in the past, the docket is as large now as it ever has been. The cases are varied in terms of subject matter and parties. And the size and the content of the recent docket, and lucky for me, for the past 8 years, it has been a busy docket, that could suggest that this court is very well positioned to perform its assigned functions of settling disputes and developing international law in the course of doing so. But let's take a step back a bit from the current docket, and let's look at the acceptance of the court's jurisdiction more generally. In comparison with the aspirations of those at the Hague Conference, we have to say that the court has not met the expectations that they were hoping for. Why? Because if we look at the number of optional clause declarations whereby states accept the court's jurisdiction generally, there are currently, I think the number right now is 73 states. So fewer than half of UN member states have accepted the court's jurisdiction generally. And some powerful states have been very hesitant to consent to the court's jurisdiction. In addition, states have at times reacted to their disappointment with decisions of the court by distancing themselves from the court. So if we step back a little bit further from the court and we look at developments in international adjudication more generally, we might also point out that there have been recent and well-known examples of non-appearance by respondent states in state-to-state proceedings in other courts and tribunals. And then here in Geneva, as many of you know much better than I do, there are serious difficulties now at the dispute settlement body of the World Trade Organization. So far I'm still talking about dispute settlement, but we can step back further still, and we have to locate these difficulties that we face in international adjudication in the broader context of world affairs, where we know that sovereignty is being invoked in a variety of settings and by a variety of actors to criticize many sorts of international institutions. I've heard this trend referred to as the globalization of anti-globalization, and I don't have the impression that it's on the wane. So how should we as a community of international lawyers react to these doubts that some states have had about international adjudication? The way that I think about the general issue is, it seems to me that, bearing in mind that there are many international courts and tribunals today, we should have the goal of making them collectively and individually attractive as venues for dispute settlement. And for that reason, I think that the proliferation of courts, which is sometimes identified as a cause of concern, is also an opportunity, because it means that states can borrow ideas from each other and also that they can compete with each other. And I always think of my phone when I think about competition, and I ask myself, this phone is pretty nice, it has a lot of good features. I wonder what it would have looked like if it had been developed in a planned economy under a 5-year plan. Probably not so good. So I think competition among these courts and tribunals is probably all to the good in terms of making adjudication and arbitration effective and attractive. But I think we also need to ask ourselves, what are the right expectations to have for these international courts? And here I go back to the contrast between the doubts that I hear sometimes from states about international courts and tribunals, as borne out by some of the numbers that I mentioned earlier, on the one hand, and the views that tend to prevail among scholars and students of international law, who generally have a favorable view towards international courts. And I want to focus in particular on a common theme that I see in scholarship, and that is the wish on the part of many scholars that the ICJ would do more than it does already to elaborate the substance of international law, to engage more vigorously in the progressive development of international law, and to use our decisions and the decisions of other courts also to set out what is often described as a reliable and authoritative narrative on disputed facts. So why do we hear these themes so often in our international law community? I think that the answer, to put it succinctly, is basically that we have an institution, the ICJ, that has the nickname World Court, but we don't have anything that could be described as world government. So we have many international courts and tribunals, but there are very few circumstances in which interstate institutions exercise functions that would be analogous to legislative functions at the national level, or to the functions performed by an executive branch. So the General Assembly passes resolutions, but they're normally not binding. The Security Council can pass binding resolutions that are law for all states, but it rarely does so and has limited scope in any event to do so. Treaty making is a source of positive law. Treaty making continues, but many of those who seek to promote new rules of international law can be very frustrated by that process. It's very slow, and it's very difficult often to conclude instruments that are acceptable to a wide range of states. So given that broader context, I can certainly understand the frustration that leads to the hope that international courts generally, and the ICJ in particular, will step into the breach and perform what is sometimes called the governance function. So when people talk about a governance function for courts, what they have in mind is that in addition to the backwards-looking determination to settle the dispute, the court can, and some people would argue should, make broader pronouncements with the effect and perhaps the intention of influencing also the future behavior of states that are not parties to a case. So it might seem at first blush that a court like the ICJ is strengthened, that it's strengthened its role and its importance if it moves beyond the settlement of disputes and pushes itself out to exercise more of a governance function. Well, my experience is that when the court makes significant pronouncements on the existence or the content of legal norms that were not well clarified before that, those pronouncements get broad attention and approval often within academic circles. But I want to encourage attention within this academic group to think a little bit about the ways in which over-enthusiasm for such broad interpretations and pronouncements on international law might actually weaken the court instead of strengthening it. And this ties back to my earlier observation about the fact that we need states to consent to the court's jurisdiction and to bring cases to the court in order for the court to perform its role of settling disputes and developing a jurisprudence. If they're not there, we can't do either of those things. If they perceive of the court as taking liberties with its assigned role, there is, I think, a concern that they may decide to distance themselves. Also, there's a second reason that I think we need to ask ourselves about the premise that ambitious pronouncements on international law actually strengthen the court rather than weakening it. And here I'll just use one specific pronouncement of law as an example. And the example is in 2010, and this was before I joined the court, by the way, in a case known as the Pulp Mills case, the International Court of Justice stated that under general international law, states had an obligation to undertake environmental impact assessment in respect of activities that might have a significant adverse transboundary harm. The court did not cite any state practice or opinio juris to support that conclusion. And that statement of law was worded in such a way that it applied to all states, not just the parties. And it was welcomed by academics in the field of international environmental law. And it is, as far as I can see, taken as an authoritative statement of law in numerous textbooks on international environmental law. So after that judgment in 2010, the question of environmental impact assessment was back in the court, and Professor Cohen was involved in this case representing one of the parties, two cases joined together involving Nicaragua and Costa Rica as the parties. In that case, the parties had quite a bit to tell us as a court about what they believed was state practice in relation to environmental impact assessment. And two things were clear to me. The first was that there were very few states that engaged in any systematic way in environmental impact assessment in a transboundary context. And the second one was that there was no indication in any of the materials that I studied that any state had begun to assess environmental impacts in a transboundary context as a consequence of the ICJ's pronouncement in 2010. So it left me wondering more generally about the effect on state behavior of our pronouncements on law. And I can't tell you that I know the answer to that across the board. I am really more pointing it out as a suggestion that it needs more consideration and more academic study. Whenever I speak before academic audiences, I try to convince them to study things to help me to figure out the answers to questions that I can only ask but can't answer, and that's one of them. How do we know the extent to which general pronouncements of law by the International Court of Justice influence state behavior? If anyone would like to study that as part of a thesis, please do so. This line between law identification and lawmaking is not always clear. And the court often has a choice about whether to state its reasoning in broad terms or to write its conclusions narrowly in a very case-specific way. That choice is never easy. Judges often disagree about the best way to do it, and we are a group of 15, so that can make it quite difficult. But although there are these opportunities, I think we have to approach them always within the scope of our primary mandate in these cases to settle the dispute. So we can develop the law in the course of settling the disputes, but I think we just need to be cautious and recognize that if we go too far in doing so, states may be made apprehensive about that, and the net effect of that could be to weaken the court rather than to strengthen this. There are other ways that the court itself could make itself more attractive as a forum for settling dispute, and I'll just mention a few of those briefly. So what would it take to make the court attractive to states? Well, one thing we shouldn't do, even if we wanted to, I don't think it would be helpful, we can't game the results in the cases. Why? Because there are two parties in any case. So if we decided, well, let's make state A happy, we'll make state B unhappy. And that would be true for jurisdiction and the merits. So we can't play with the outcomes. We have to decide the cases the way a majority of the court thinks they should be decided. But what we can do, and we are pretty good at it but need to do better, is we need to set out clearly the reasons for our decisions. It needs to be clear, especially for a state that loses a case before us, why it lost. It needs to understand that we heard its arguments, that we appreciated them, and why we were not convinced by them. In addition, our working methods as a court are old-fashioned, and we are often criticized as too slow, too passive, and not amenable to change and adaptation. So I think we as a court need to take advantage of ideas and opportunities for borrowing from more modern courts and tribunals, always with the goal of making the court attractive as a fair and effective place to settle disputes. Outside of the court, there's also work to be done. The process of selecting international judges, including those in the ICJ, has been the subject of extensive study and has faced justifiable criticism. And here I would just note that the nomination process within states, in almost all cases, fortunately not the United States, is not transparent. And the expression old boys network is widely used to describe that process. And here, the use of the male gender old boys is justified. In almost 100 years of the existence of a world court, there have been only 4 women judges. 3 of us are now on the court. And lest you think that's a trend, 3 out of 15, I should point out that in the last ICJ election, 6 candidates were nominated for 5 seats, and not a single one of them was a woman. So there's work to be done there. The election process in New York also suffers from practices like vote trading. I'm sure you have that in Geneva as well. Geographic distribution is given prominence, and it should get that prominence. It's, I think, very important. But in this atmosphere of vote trading, individual qualifications, I think, get very little attention. I often felt when I was campaigning for the court that it might not matter very much who was there. I think I might have even said sometimes I felt like I could send one of my sisters, none of whom are in law. But they look a fair amount like me. So these are some suggestions about ways in which international lawyers inside the court and outside the court can contribute to making the court attractive to states as a place to settle disputes. And I'm aware that I'm offering suggestions that are, in a way, kind of back to basics and something that really goes back to some of the nuts and bolts considerations in adjudication. I just encourage that it's especially important that we explore these issues and think about them carefully at this particular time. Because, as I've said earlier, if we want the court to be successful in settling disputes and in developing jurisprudence, it needs a broad and diverse and full docket. That's the way I think that we would fulfill the aspirations of those at the Hague Conference for the International Court of Justice. Now, before I finish up, just briefly and mention some similar points that I see with respect to investor-state arbitration. So as with the ICJ, it's helpful to start by thinking about where did this form of dispute settlement come from? Well, before investor-state arbitration, or where it's not available, the mechanisms for addressing disputes between a foreign investor and a state are basically local courts or diplomatic protection by the investor's own state. States have only rarely espoused the claims of their own nationals and their own investors especially. And so investors from capital exporting states were not happy with that. And the World Bank sought to overcome these difficulties and to increase capital flows with the Convention for the Settlement of Investment Disputes, the ICSID Convention, by creating a mechanism for the direct settlement of investor-state disputes in a neutral forum. But just as the ICJ statute does not require UN member states to accept the court's jurisdiction, the ICSID Convention leaves state parties and investors free to use investor-state dispute settlement or not. And of course, they have done so. There are many treaties that embrace investor-state dispute settlement, and many cases, hundreds of cases, have been brought. Well, at the moment, the field of investor-state dispute settlement is under a lot of discussion, busy and under active discussion. It's a field that has shown itself in its relatively short lifespan to be very dynamic, and examples include recent ideas on the evolution of confidentiality versus transparency, mediation as an alternative, ICSID's ongoing rules amendment project, and proposals to replace the investor-state arbitration with an investment court. I'm not, of course, going to go into all of these proposals here, but the one observation I wanted to offer is something that parallels the point that I was making earlier in my comments about the International Court of Justice, which is just as the ICJ can only meet the aspirations of those who created the idea of a world court if states embrace it both as respondents and as applicants, any mechanism that we develop to settle investor-state disputes must also meet the interests of both states as respondents and as investors as claimants, because if that's not the case, disputes will not be brought to a new court or whatever other mechanism is developed. And there's reason to doubt that that would be a desirable outcome. So to sum things up, when I think about the ICJ and about investor-state dispute settlement, and then I look around this room, it occurs to me that those two forms of dispute settlement are older than almost everybody in this room. But that doesn't change the fact that these were very bold ideas when they were proposed, and they remain bold today. International adjudication arbitration asks a great deal of states. They are expected to place their trust in international adjudicators and arbitrators and institutions whose decisions will be binding on them under international law. They're expected to maintain that trust even when they don't like the results in particular cases, and even when that particular state loses a case. So these ideas were bold, they remain bold, and at the same time, we find ourselves in a period where powerful voices in various places of the world criticize international courts and other international institutions, including those involved in peaceful settlement of disputes. So those of us in the profession of international law, I think, need to listen to those concerns, and we have to be prepared to counter exaggerated criticisms of international courts and other institutions. But at the same time, we have to be vigilant to look for opportunities to improve and to strengthen these institutions so that they are vibrant, so that they are thriving venues for settling disputes peacefully and in accordance with international law. I'll stop there, and I'm happy to take questions. Thank you to all of you.
Thank you very much for your very stimulating presentation. You raised a wide range of aspects of the work of the ICJ and other adjudicative bodies. I'm sure there will be questions on many of them. I have to say that it was a very pleasant experience for me this time to be seated and to hear you instead of appearing before the ICJ, although I very much like to do so. So before giving the floor to the audience, I would kindly request those taking the floor to be aware that judges of the ICJ cannot answer questions concerning pending cases or disputes that can come before the ICJ. So please take this into consideration. Be as succinct as possible in your questions, and without any further comment. So I give the floor to the audience. If you have questions, please raise your hands. There are microphones. So we have a first question.
Hi, can you hear me? Yes. My name is Esma, I'm from Qatar. I just have a simple question. There are many claims that the International Court of Justice, as well as other courts, are highly politicized. So I just wanted to hear a few words on that.
You want to take several questions, or?
Yes, we can take other questions, and then Judge Donoghue will answer. There is one question here.
Yes, Douglas Reichert. I'd like to ask about the court's practice with respect to recusals, and basically directed at the history of such practice, because I'm personally unaware of it. And of course, grateful that you're here in Geneva today, thanks to that. Have you studied, Judge Donoghue, the history of prior examples, such that you might be able to comment on judges who were in the same situation in which you found yourself, did or did not recuse from cases brought before the court? And perhaps in light of that history, any comment on what is the effect or importance of the practice of judges recusing themselves from cases with respect to the institution?
Thank you. Maybe we can collect two more questions, and then, yes, please.
Thank you. Hi, Judge Donoghue. Shashank. I work at the appellate body of the WTO, obviously speaking in my personal capacity here. I have a question which is about the non-disputes related work that international adjudicators can do to enhance the legitimacy of the court, because you spoke about going to Idaho, and I know you travel a lot and you take that part of your job very seriously, where you have the responsibility to also increase awareness about the work of the court in the US, which is the country of your nationality. And I'm just wondering, in such times, to what extent do judges and those who support those judges bear a responsibility, if at all, to increase public understanding of the institution's work, and to, remove misunderstandings? And does that actually work? I mean, when you go to the US and to these law schools where, say, people haven't heard about the court's work, do the skeptics end up coming out as more accepting of the court's jurisdiction? And is that something that we should all be thinking about in these positions? Thanks.
One more, and then...
Hello. Well, first of all, thank you so much for your very interesting presentation. You briefly mentioned the crisis that the WTO is undergoing at the moment with the appellate body. So I was wondering if you could briefly comment on your view of what the WTO will look like, and also since rulemaking is very complicated in this setting, which role the appellate body will play.
I don't have to do anything.
No, it's okay. You can.
Well, let me start. First, thank you for all the questions. Let me start by disappointing the last questioner. I can't answer that question. I would only be guessing, speculating, and in general, I wouldn't feel comfortable doing that for a number of reasons that I think you probably can understand. Shashank, who worked with me at the International Court of Justice and is now at the appellate body. Your question about outreach, I guess we could call it. First, let me say the ICJ has no budget for that at all. So the opportunities that I've had have all been a consequence of invitations from others, usually, although not exclusively universities, but almost always universities. When I go to a university, if I have the right kind of host in the United States, I will often work with them to develop a broader program of activities. So I've done public television, public radio, legal newspapers. There's a legal newspaper in Los Angeles, meetings with local judges, et cetera. So we sort of build out from that. I will tell you that I feel like it's kind of like bailing the ocean with a thimble, because there's just one me and there are a lot of those other people. And I don't think there are very many people on courts or even in the international law community generally that do this. And when I look around the American Society of International Law, I don't see other people going out to meet school teachers and others. Does it make a difference? Maybe. I mean, the way I think about it is I'd like people to not be influenced simply by whatever soundbite they hear. And I try to identify people who I think might be thought leaders in their own communities. So practicing lawyers in a local community who might have nothing to do with international law are still going to be the people who are looked to if there's a discussion about law. One of the examples that I've been able to use sometimes, for example, is the Disabilities Convention. It's a convention that was modeled largely on U.S. law. And it did not get the approval of the U.S. Senate, and many of the criticisms of it were very exaggerated criticisms related to, for example, it would shut off homeschooling and certain other things. And my basic effort is not to tell them, here's the right answer, here's what the U.S. should decide, but rather to get them to understand that they should make their own judgments and really try to think carefully about these questions, not simply to be led by somebody who might have his or her own agenda. Is the ICJ politicized? So the difficulty with that kind of a question is I don't really know what an individual might mean by politicized. The most frequent assertion that aligns with politicized is the assertion that's sometimes made that nationality dominates the decision-making of individual judges. And that I don't find to be terribly convincing, primarily because each judge has so many different aspects of his or her background. Gender, not so much variation, as I mentioned earlier, but we come from 15 different states. Some of us, like me, were foreign ministry lawyers before. And so often those of us who were foreign ministry lawyers, when we talk about treaty negotiations and treaty interpretations, we do that from the vantage point of people who have been in the room negotiating treaties. And that's a somewhat different perspective than somebody might have if they'd been academics. The academics bring a different great strength to the court. We have some former national court judges. We are various ages, big span of age until my former Japanese colleague retired. I think there was probably a good 25-year range in the court. We have different backgrounds in terms of the areas we've specialized in. So I think it's very difficult to conclude that nationality dominates the way that we behave, and I would challenge anyone to really make a serious case that's the major reason for the decisions that we make. Recusals. That's a complicated question. The ICJ statute says very little about recusals. The reason I was pulling out my iPad is I was getting that out after the question. And I, of course, didn't find what I was looking for. But basically, there aren't very many recusals. When judges join the court who have been advocates before joining the court, they frequently had particular association with cases, and they clearly can't participate in that case. Other than that, when a judge considers that he or she should recuse himself or herself, it's largely a matter for the individual's appreciation The considerations have some similarity to the considerations that might be relevant in arbitration or in national legal systems, but they vary quite a bit. But I would say that the general approach is, on the one hand, that we have a duty to appear and participate as a judge, except where there's a genuine reason to step aside. Sometimes it's necessary to have a discussion within the court. Sometimes it's clear, and that's all that happens. Parties can raise the issue, and they sometimes do. And by the way, the history of recusals until up through 2012 or so is set out in the treatise on the ICJ that can be reviewed. And people sometimes, instead of raising directly the question whether a judge should recuse, they'll sort of hint at it as well in private correspondence with the court. So I think I've covered those questions.
Thank you very much. So we can go for a second round of questions. Please here. First round. Okay.
Good evening. I'm Ashwini. I'm from India. I'm a master's student in development studies here. At one point, you mentioned that the proliferation of courts is not necessarily something to be despaired, but rather to be celebrated in a sense through accepting competing forums. But wouldn't that encourage forum shopping? And what are your thoughts on that?
Good evening. I was wondering what would you think about the abstract and very theoretical idea of an executive and police force tied to international courts and tribunals, and as well very abstract and theoretical idea of an autonomous financial mechanism for international courts and tribunals?
My name is Rabab Yassin. I have two questions. One linked to Douglas's question of recusation. Is there a challenge process, or is there a way a party can challenge one of the judges? And the second question is related to the jurisdiction issue. You said that states could decline jurisdiction. Is there a time frame, or is it per case, or is it in the absolute sense, because you mentioned 73 states? Thank you.
I can answer those. I can do this. Okay, so forum shopping. So we have to think about the ways in which this could unfold. In the first instance, if a state gathers its lawyers in-house and maybe outside lawyers together and says, we've got a dispute with another state, we feel we're at an impasse, we've tried various non-judicial means to settle it, now what can we do? From my perspective, the longer the list that the lawyers can present, the better, because some things that the state might consider we don't want them to do. I mean, as international lawyers, we might think of one of our core roles as coming up with alternatives to the use of force. So the bigger the menu of options other than using force, the better. So at that stage, as far as I'm concerned, if the lawyers can identify more than one forum that might be available, let them study it and let them choose. And that idea of forum shopping doesn't bother me at all. I would like to see them have many paths and possibilities. And depending on the dispute, there may be some. It may very well be, though, that when they do the analysis, they can only find one where they think that jurisdiction is available or at least plausible, where they can make a try at it. The difficulties arise, I think, theoretically at least, if the state or other party initiating the case seeks to pursue the same issue in more than one forum. That can become very difficult. And certainly, although I don't see as many problems with proliferation as some might, I'm not suggesting that there are no problems. Certainly there can be issues. But in general, I think that the availability of multiple options is a positive, and yes, it can be complicated. But I think of international law as just generally very decentralized. So maybe because I have always thought of it that way, I'm less bothered by the fact that proliferation can pose some difficulties. I would rather have proliferation than what we had, say, in the 1970s, where there was the International Court of Justice deciding one case a year and not much else going on in the way of international adjudication or arbitration involving states. So I'd take proliferation over that any day. I don't have anything to offer in terms of your question. I would just say that I try to focus my energy on problems and solutions that I think are within the realm of the possible. Even the ones that are within the realm of the possible seem difficult. Getting what I think are sort of modest changes in ICJ procedures seems difficult. Professor Cohen mentioned a conference that we participated in. Lots of ideas were generated. I'm not sure we've followed through on some of those. Partly that's a consequence of the size of our docket. It's difficult to do that kind of work when we're as busy as we are. Challenge process, yes, states certainly can raise a concern, and they do sometimes raise a concern that they think a particular judge should not sit in a case. That happens. In terms of jurisdiction, just to back up a little bit, there's no jurisdiction unless states consent. They can't change their mind after a case is filed. They can't say, oh yeah, we consent generally to that ICJ, but we don't really think that's such a great idea now that we have an actual case. It doesn't work that way. But there are many different ways they can consent, so the 73 number is definitely a disappointment. There are many other ways that states can expose themselves to the court, and many of our cases, in fact, come to us through those other mechanisms. So it's a question of how much consent they have given, not how much they will take away, I think.
Just a comment. Does it work?
No.
It doesn't. Is that okay?
Yeah.
Okay. Just a brief comment. Speaking against the idea that the ICJ is old-fashioned and then we have other tribunals working in a more efficient and technologically speaking better way. So if you compare the amount of documentation states submit to the ICJ and the amount of documentation you have in investment arbitration, you will be amazed and you will think that the ICJ is working in a better manner than investment arbitration tribunals. But that's a short comment. And maybe I can abuse of my position of moderator and raise a question. So it's not relating to proliferation, but with regard to alternative methods to adjudication. So last year, we witnessed a successful procedure in the field of conciliation. That was the Timor-Leste, Australia case under the United Nations Convention on the Law of the Sea. So conciliation was rather dormant. So after this successful story, do you think that there is a future for conciliation and there are disputes that are better suited for conciliation rather than ICJ?
Maybe. I was very lucky because Professor McRae, who was a member of that Conciliation Commission, was also, soon after it finished its main work, was sitting with us as an ad hoc judge, and his office happened to be next to mine. So I offered him lunch and invited him to lunch and asked him to share his experience with me, which I found fascinating. The one thing that I have thought about on being on a court, as compared to being a foreign ministry lawyer, where you're settling disputes directly without a third state, without a third party imposing a decision, is I've often felt that if you're in a bilateral context, you paint with on a bigger canvas and with many more colors on your palette. On the court, we have very limited things we can do. We can't say, well, it really would be a great idea if Costa Rica and Nicaragua, instead of doing what they're pleading to us, would just do this or that. And it's frustrating because sometimes we see things and we think, well, why can't they do this or that? So this formal process has advantages. It's very structured. And at the end of the day, we render a decision. And sometimes the fact that we will render a decision that's binding is actually what's necessary to settle the dispute. Sometimes the impasse is a result of an inability politically of the two states to settle the dispute. Conciliation is a nice middle in the sense that it brings in what are perceived of as authoritative outsiders to offer ideas, etc., without that final decision by the outsider that's binding. And there is more of an opportunity for exchange between those outsiders and the states that can potentially move closer to an outcome that would be desirable. So I'm very interested in it, and it's similar to the developments of mediation in investor-state dispute settlement. Hard to say whether it will attract more attention, but certainly there are ideas that are worthy of development and encouragement. Yeah.
Thank you. Now we can go for a third round of questions. There are many over there. Professor Avisab, you have a question?
Would you accept a short comment instead of a question?
Absolutely.
Thank you. Well, it's really a comment in self-defense, because you said that academics expect too much from the tribunal, which can be counterproductive by weakening it. My comment is what in French you call un dépit amoureux, meaning love disappointment. I've been a court watcher and sometimes outside, inside, etc., for more than 5 decades. And what disappointed me, not always, but in few cases all the same, is how the court tries to evade important issues which are essential for the case before it, but they are politically sensitive. And this is not asking the court to exercise judicial activism or to elaborate what is not before it. But the people expect it to answer. I'm sorry, but I have to give an example. The advisory opinion, for example, on Kosovo, it's basically a question of self-determination. And the court completely evaded it, completely, and gave an answer which I still don't understand. Earlier, much before your time in the court, in the Lockerbie case, there was another something of this. Well, I can give a series, but I'll stop there. And so I don't think we expect the court. I know that there are 2 schools from the beginning. Hudson, for example, was for a court that would expose the law. Later on, Jessup, American, Lauterpacht, others say no. In my own experience, in one case I was sitting as a judge ad hoc, one former president of the court came and told me, George, he knew that I am a little bit of a theorist. We are here to solve the problem, not to go beyond that. So these are two trends within the court. And I understand that the court exercises judicial caution, but evading the main question, which everybody expects an answer on, sometimes is frustrating. Thank you.
Well, this was a statement. And Professor Abisab knows that I will always allow for this kind of exception. So, but if there are other questions, please.
Good evening, my name is Vinayak.
Microphone, please.
Yeah. Good evening, my name is Vinayak. I'm from the MIDS program. Sure. My question is that we're presently living in a political environment where I think at least 3 out of the 5 permanent 5 members of the United Nations are taking very extreme positions on international issues and causing trouble to a lot of other states. Given that the P5 is in the position to block enforcement of ICJ decisions, do you think that the court faces some sort of threat or crisis in the coming decade?
Other questions? Microphone here, please. Here.
Thank you very much. I am afraid I want to go back to the politicization very, very quickly and briefly. I agree with you. One could have different interpretation from what politicization is. Of course, it is whatever it is, different means, but it is all about influence. But I fully agree with you that nationality is not necessarily that means, and of course depends on the person who is there and how it is done. But talking about a hypothetical case, let me also say the nationality, I agree with you, even though some nationalities are fixed in the court and they don't change, so they are always there. But still, I mean, giving the benefit of the doubt, yes, because of the quality of the judges who are appointed, so the nationality could not necessarily be a means of influence by itself. But what seems we are seeing now these days, that some of the states are expanding those nationals, multiplying them. I mean, we have appointed judges and we have ad hoc judges. But some of the states now, I'm trying to be a bit vague, some of the states now are using their fixed judges, but then they appoint sort of ad hoc judges when they have different cases. And this seems a way like multiplying that nationality in the court and enforcing that. Do you think this will, the situation that the court is dealing with, the recent cases, do you think that's a good example that will not affect the case, particularly at the time that the case is, I heard Professor Abisab, but at the time that I think the court is standing up a bit, is being more open, trying to take up some of the issues. It has a good composition and all that. Thank you.
We can take another question, maybe. Please. Who has the microphone? Please go ahead.
Good evening. Can you hear me? Yeah, thank you. Good evening. My name is Danish. I'm from the South Center. I have a two-part question, but it's really quick. One, when you say you're promoting competition among courts, we see that a lot of courts at the international level are quite specialized, like, say, the Tribunal for Law of the Sea or one of the criminal tribunals. So what exactly is the thing that they're competing on, is my question. Second, when you have competing courts, how do you deal with the issue of different authoritative interpretations of the same norm, like which has been seen in the many ISDS cases? Thank you.
I couldn't understand the second question. I didn't understand that second question.
So how do you deal with the problem of conflicting authoritative interpretations of different norms coming from courts or of the same standing? Thank you.
Well, Professor Abisab, first of all, thank you for being here and thank you for your comments. Actually, I think you set out very clearly the counterpoint in many respects to the point that I was making, reminding people that of the depth of disappointment that there can be when the court doesn't answer a question, even when, as you described it, there really was an expectation that the question would be answered. I would, and Kosovo, I wasn't on the court. I made the U.S. submission, but there were very divided submissions in terms of what the exact question was, and quite a few of them put forward the proposition that self-determination wasn't at the heart of the case, and that's obviously where the court came out. But I think. Yes, the only thing that I can say, and I hope this corresponds with your extensive experience, is that the decision of whether to, if you will, write broadly or narrowly is weighed very, very carefully every time we face it. We face it really in every case, often multiple times in each case. And there are strong views often within the court about whether we should go beyond or not. Quite honestly, one of the problems, depending on the case, but if the issue has a more than a purely legal dimension, if it has also a factual dimension, we don't always get materials from the parties that really are sufficient. And sometimes a question, I feel, we are not in a good position to answer a purely legal question simply because it hasn't been well briefed by the parties. Okay, we can go off and do our own research on a legal question, but there's some degree of discomfort in those cases. Still, I certainly respect your views as I must. I'm not worried about the difficulties among the P5 are worrisome for many reasons, but the relationship to ICJ judgments doesn't worry me, primarily because although it is theoretically available to a prevailing state to go to the Security Council and seek measures to be taken to effectuate the decision, it doesn't ever happen. It happened once, and the U.S. vetoed, but why hasn't it happened in all these other cases? One reason is that compliance is generally good, luckily. But even when there isn't compliance, one has to assume that states make a decision that they are better off addressing the problem in other ways. And I'm not sure that the reason they don't go to the Security Council is because they're convinced that one of the P5 or another would veto. Because in some of the cases where there's either slow compliance or non-compliance, I'm not sure that that really would be the obvious result. I don't have much to say about your question. My judges don't recuse themselves except when they need to. And if they are replaced by, if a state does not have a judge on the court of its nationality, whether there is normally such a judge or not, it's entitled to name a judge. It doesn't have to name a judge of its own nationality, and they often don't. But there's nothing, from my perspective, that gives a particular state an advantage when it has a judge of its nationality, and that judge has to step aside because of prior work, and then is replaced by an ad hoc judge. I would say, in general, I would like to think that judges who've been on the court for a number of years are probably better positioned to be effective in a particular case than an ad hoc judge coming in new. Obviously, we have some former permanent judges who return, and they may be in a situation similar to the sitting judges, but even they have been away for a while, and that can cause some difficulties.
Maybe we can go for a last round of questions, if there are some. Please.
Hi, my name is Pascal McDougall. I'm a doctoral candidate at Harvard Law School and currently visiting the Graduate Institute. So I have a boring, apolitical, non-substantive question about institution building. So it should be a safe one. And it's about your view about the role of clerkships and clerks in promoting a court and an institution, building its reputation and fighting the backlash that you identified. Now, you may have touched on this in a response to an earlier question, I'm not sure, but I wonder what your views are, right? So I'm from Canada, and there, like in Israel and South Africa, and to some extent the ECJ and a few other places, that we imitated the American model of the Supreme Court, where clerks are really influential in legal academia, they teach the materials of the court, and they create demand for further clerks to then come back to academia and promote the institution. And some of these places, the courts are recently influential, and therefore, then they're really influential, right? They've had rights revolutions, and they've been recently massively empowered. And anyway, the clerks basically run the show. So it's been a successful model, I would argue, at the domestic level. I mean, I wonder what you think the role of it is at the ICJ level. Thank you.
Robert Reyes, I wondered if you would care to comment on what Josh Bolton finds so objectionable about the International Court.
My name is Solomon, and my question, I'm going to be very quick here. You said that there's a lot of avenues for international issues to be addressed by different courts, like the International Criminal Court, the ICJ. And given that, and isn't it what do you think going forward for your court is that to focus consistently on the member states, the countries, the 77 countries that accept your jurisdiction. That way you create a consistency and you are enabled to be effective and consistent, which is a very key issue. Thank you.
I think you're referring to John Bolton, not Josh Bolton, formerly of the Office of the Legal Advisor, someone I've known for a long time. I don't have anything to say about John Bolton. He's more than capable of speaking for himself. And if you watch his statement, he made a statement recently about one ICJ case, but he also gave a talk on the International Criminal Court. And if you watch the video, he addresses some broader themes in question and answers later, so it's easily accessible. The so-called boring question about courts, I'll just have to say that I participated in a conference in the memory of David Caron, and I know one of David's close friends, Doug Reichert, is here, and one of my co-panelists said during the presentation that, he said, well, I know rules of procedure aren't sexy, and I said, I'm filing a dissenting opinion. How can you say, John Crook, that rules of procedure aren't sexy? And similarly, how can you say that the role of clerks is boring? And my former clerk, Xavier Baptiste-Rodin, is here today. He's Swiss. He left me after 4 years a couple months ago, and I'm happy to say came from Bern to join this presentation. So he knows more about this than I do. But you know, so the ICJ did not have clerks originally. New York University proposed to the court that it would send it would fund 5 people to come after graduation to serve in a clerk-like role for the entire court. And that program eventually expanded so that there were 8, so each judge had shared one of those people with another. And then over time, the UN agreed to make one UN-funded law clerk available to each judge, and actually the arrival of the the full range of clerks, such that each judge had one clerk, coincided to the day, really, with my arrival at the court. So ever since I've been there, we've had one clerk, and there are more universities interested in this other program, which we now call the Judicial Fellows Program. And we have one almost, I think, every year from the Graduate Institute.
Unfortunately not.
No?
Unfortunately not, but we have many former students from the Graduate Institute working at the ICJ.
Yeah. So a lot of our clerks former clerks do pursue academic positions. They do not, I would say, function in a way that's identical to the way U.S. Law clerks operate. And I think that's partly because the volume of work that goes through the chamber of a U.S. judge at the trial level, at the appellate level, at the Supreme Court on the federal side is phenomenal. And they have their clerks doing a substantial amount of the drafting, and that is not the tradition in our court. The tradition is much more for the clerks to be providing research assistance. Of course, each judge has a very different working style. My style includes a lot of back and forth with my clerk, and lots of questions and exchanges that I find very rewarding. Xavier can tell you whether he finds it rewarding. Should the ICJ focus, just to step back, any member state of the United Nations can appear before our court. And although the number that I mentioned, 73, those are the states that have accepted the court's jurisdiction generally. There are many other ways that states can and do accept the court's jurisdiction. And in fact, many of the cases that we have pending on our current docket, the basis for jurisdiction is not the general acceptance of jurisdiction. It's rather, for example, jurisdiction on the part of the court to decide cases arising under a particular treaty, a treaty on the elimination of racial discrimination, for example, a treaty on terrorist financing, for example, treaties on diplomatic relations. Those all have vehicles that provide a basis for ICJ jurisdiction, and many of our cases come to us in that way. So we don't specialize. In fact, I think the court is unusual, and probably one of its great strengths is the fact that we are open to any cases on any aspects of international law, very much a generalist court.
Okay. Well, I think that we can stop here. Again, I thank Judge Donoghue for her very stimulating presentation and the answers to the numerous questions raised by the audience. I would like to take this opportunity to thank, on behalf of the Graduate Institute, to the Permanent Mission of the United States for this collaboration, and I look forward to continuing this collaboration in the future. Thank you very much.